SJC-12055, Commonwealth v. Marcus Thomas.
Good afternoon, Your Honors. My name is Heidi Ort-Gaskell, and I represent the Commonwealth in this matter. With the Court's permission, I would like to first briefly discuss the Commonwealth's appeal before moving on to the defendant's appeal. The Commonwealth is appealing the motion judge's decision to suppress the identification of a firearm. In this case, it was a handgun. The law of identification procedures for people and inanimate objects is not the same as this Court recently explained once again in 2015 in the Brazella case. And this is mostly because mass-produced objects and which are inanimate objects, are very different than people that have unique facial features or unique characteristics.
Even if one accepts that, the whole scenario and the comments and the confirmatory statements made by the police, should we just forget that?
I would say that that does not rise to the level of a denial and due process in this case. She identified the weapon prior to the statements by the police officers. The show of one photograph, which the motion judge found particularly troublesome, is not an issue with inanimate objects because a handgun looks like a handgun looks like a handgun. So one photograph over another photograph, it's going to look like a black handgun. She identified it to the best of her ability by saying that looks like the gun, which is all we would expect a witness at trial to be able to say. That looks like the weapon the defendant had on that day, during the incident. As far as the confirmatory remarks...
I'm sorry, so what do you think the judge barred you from doing? The judge barred you from saying that that looks like the gun or that that is the gun? Because there was a reference to the markings on the side.
Right. The judge barred the identification entirely.
By her?
By the witness, yes.
But the gun can come into evidence.
The gun itself can still come into evidence, yes.
And is she, in your view, can she testify that it was big and black and looked like a police weapon or not?
I believe she still could, because that's how she described it to police officers prior to her identification of the weapon. During the first interview, she said, this gun looks big, it looks black, it looks like police officers' weapons.
So, as a practical matter, what have you lost?
As a practical matter, the Commonwealth does not want to set the precedent that motion judges can get rid of inanimate object identifications.
But can't a judge, I mean, the judge did it not only on due process ground, but also on evidentiary ground. Can a judge do essentially under the common law of fairness, sort of a 403 analysis, and say, I think it's more prejudicial than probative in light of the police conduct here, that I think it's not sufficiently credible, and therefore I think it should not come in?
The motion judge could, but that's not what happened in this case. In this case, it was a motion to suppress. It was not a motion in limine. It was not argued.
It's a motion to suppress the identification.
It was a motion to suppress identification. It was not a motion to suppress the firearm. It was not
Right.
A motion in limine to suppress based on evidentiary rules. It was a motion based on due process. When you read the defendant's memorandum, all of the arguments were due process arguments. When you read the judge's decision, they were all based within a due process argument. So there was no evidentiary ruling as far as whether or not the gun could come in. Her identification.
No, but I think we're all talking about whether she could identify the gun at trial.
Right.
Right. So both constitutionally and for evidentiary reasons, arguably,
Yes.
she should not be able to.
I would argue, I think she can. The motion judge, I believe, was wrong in disallowing this. I think that her statement that she had of a viewing of the gun, she saw it in the car. She was able to use her hand movements to enact how the defendant used the weapon. And when you view the video of the interaction with her with the police, the interview with her police, you can see her using her hands. He did this, he moved the slide, he held it like this. And so she had a great viewing of this weapon. So anything that the police did as far as confirmatory remarks, if that's what they were, which the Commonwealth does not concede, that the police actually did confirmatory remarks.
Okay, now, that's the last statement. The last line before the order says, "I find therefore that the detective's use of confirmatory feedback contributed to the impermissible suggestiveness of the identification procedure, and the laws of evidence require Johnson's identification of the gun be suppressed due to its unreliable, unfair, and prejudicial nature."
Yes, Your Honor.
And is that not an abuse of discretion standard to determine whether his finding that it was unreliable, unfair, and prejudicial, and therefore pursuant to the laws of evidence should not come in?
I would, although he wrote that, and that is his words, when you read the entire rest of the opinion before that, his entire analysis up until that point was a due process analysis. It was not an evidentiary analysis. And
Could I ask you a somewhat separate question about the same point, though? Given Priscilla is a jacket found at a scene.
Yes,
This is a gun.
Yes.
Found 3 or 4 days after the event. As she identified it before, it looks like y'all's. It looks like the police gun. Why was it all right to just show a single photograph? I mean, it would have been eminently possible to have this as part of not a single photograph, right? As opposed to this jacket. It might have been harder and a need to do something right away. I mean, I just don't know why you couldn't make a spread.
this court ruled that even if the Commonwealth could make a spread, that it's not required in Brazilla.
Well, but I think you have to look at, don't you? I mean, isn't it important to look at what are the circumstances in the particular case? And so Priscilla is one case. This is another. We're talking about a gun that actually looks like police weapons.
I think that goes back to the fact that this is a black handgun, and a black handgun is going to look like another black handgun is going to look like another black handgun. So an array of 8 black handguns is not going...
All black handguns look the same?
To me, no, but to someone else, it's possible that a black handgun looks like a black handgun.
I'm not really understanding your argument. You're saying that they're all, because all black handguns ultimately look the same, it makes no difference? As to whether or not a witness can identify a particular?
No, I would say, I'm sorry, that's not what I meant. What I'm saying in a photo array, that a witness might have a difficulty pulling one specific black handgun out of another black handgun. At trial, you can hold up the gun and say, yes, that looks like the gun that was fired.
So you're saying an array would be useless here? Because they'd all have to be exactly the same in color, size? I mean, I don't know how she described the gun that she saw.
She described it as big, black, and looking like police weapons. So the array would have to combine with photographic array rules. It would have to be big. It would have to be a big handgun. It would have to be black, and it would have to be looking substantially similar to police weapons.
All police use the same weapons in that?
She was
probably they do.
specifically referring to the police officers' weapons that were in front of her who were interviewing her.
Oh, okay, so she was referring to their weapons?
Yes.
Okay.
And the markings, I've not seen a photograph. How distinctive were the markings?
The markings were scratches on the edge of the gun. Most guns, when they're traveling around between person and person, as street guns usually are, do develop markings on them. So I wouldn't...
Just little scratches,
They
we're
were
not
just-
talking about anything, a tattoo or anything profound.
No. It was just scratch marks on the gun is what she was referring to. And if you view the video, the audio video of DVD that I included, you can see how she's pointing to that within the picture, and it depicts that portion better than the transcript
during
does.
the identification
During
procedure.
the identification procedure, yes. Additionally, all of this, even if, again, we would not concede these remarks were confirmatory or that the procedure was unduly prejudicial in any way, or unduly suggestive in any way, Simmons said that the harm in this case, when you're dealing with an inanimate object, is not the same as the harm as identifying a person, because you're only identifying circumstantial evidence. You're not identifying direct evidence of a person to a crime. And that is especially true in this case, where we're talking.
Was there any evidence, I guess there was no evidence of ballistics in this case?
No.
Because, okay, but I mean, there are cases in which who has the gun becomes critically important because the ballistics show that that was the gun used in the killing. And so if that's his gun, that's a huge deal.
Correct, but that's not the case in this case.
Right, but I mean, but that goes to your issue as to, are you saying that the inanimate objects are never as meaningful as the ID of a person, or that in this case it wasn't so big a deal?
In this case, it wasn't so big of a deal. The inanimate object is not as harmful as an ID of a person because, again, in this particular case, the defendant was accused of being involved in a shootout on the streets of Springfield, where he was shooting at one party and they were shooting back at the car. The victim was in the car. There's nothing that says that the defendant's gun is the shot that fired the bullet at the victim. He is being charged because he started the shootout that ultimately killed the victim. So
I know this isn't what we're here on today, but your theory of second-degree murder is he started the shootout?
yes.
Okay.
Okay, why don't you turn to the motion that you won on? Because your brother will be arguing that you should have lost.
Yes. The defendant is appealing the motion judge's decision to deny his motion to suppress identification of the defendant by the witness. There are two prongs to what he is arguing. First, he's arguing that the simultaneous versus sequential photographic array was a problem. He's also arguing that the lack of Silva Santiago was a problem in this entire procedure.
I mean, the advisories?
The advisories, yes. First, the simultaneous versus sequential. The law is not, at this time, that the police must show photographs sequentially. So a photographic array under the current law is permissible to do a simultaneous array.
I don't know the testimony at the motion to suppress hearing, but it is true that very soon thereafter or right before, the Silva Santiago protocol was followed with other witnesses, correct?
Yes.
Was there any testimony here as to why he did not do it here?
There was no testimony at the evidentiary hearing by the officers. The evidentiary hearing was simply based on exhibits and argument by the counsel.
Oh, that's right. That's right. I remember. Sorry.
So, and recently the court had the chance to review this very simultaneous versus sequential argument in Carter, which was decided approximately 2 weeks ago on September 19th. And once again, the court refused to mandate that police officers must do simultaneous or, sequential photo arrays over simultaneous. If the court decides in this case that going forward, simultaneous photo arrays are no longer the preferred method, the Commonwealth's position is that this would go to a jury instruction and not exclusion of evidence. The trending in the court so far in these eyewitness cases has been to put this into a jury instruction and allow the jury to determine the credibility of the weight of the evidence of the identification rather than to just with all these factors.
Does it matter that she was familiar with the defendant?
Absolutely. Thank you, Your Honor. And I was going to address that during the Silva Santiago portion, which I'm going to move to now. I think it is extremely important that this witness was aware of the defendant, and there are several factors in the record that the court can rely on that points to this. She was a friend. She knew that the defendant was a friend of her cousin's. She knew that she could describe his approximate age. She could describe his body type. and that's on the record at page 36. She knew his first name. She consistently called him by his first name when she was referring to him in police. Marcus got in the car. Marcus did this. Marcus did that. My cousin's friend, Marcus. It was never a friend of my cousin's. This guy I don't know. Someone that looks like this. Someone my cousin knows. She knew his first name. She says that she and her cousin picked him up. She had a good view of him. She knew who he was. She saw him standing on the side of the street as they drove up to pick him up. When the defendant called her cousin to go and see him, she drove around with the defendant and her cousin in the car for a significant portion looking for somebody. And she was aware the defendant was looking for a specific person. She knew his gang affiliation. She knew her cousin's gang affiliation. She knew the defendant and her cousin were in the same gang. She admitted to going to a party with him, but that is not the only occasion where she had seen him previously. She saw him with a gun on a previous occasion and described it to police as a revolver that was silver and black. So she was familiar enough with him to know that he carried a weapon and had seen his weapon. He was comfortable enough with her that she was with his cousin when he told her cousin, his friend, about another shooting that he had done somewhere in Springfield. So that in itself would demonstrate that they had a familiarity where he is comfortable sharing that he's in criminal activity with this witness.
So does that go to both grounds, the advisories as well as to the simultaneous versus sequential issues?
I would suggest yes, because it doesn't matter how she views the photo, she's looking for the person that she knows who this is. So it doesn't matter what the advisories are, it doesn't matter how she's looking at it. She's not looking for someone she saw that was a shooter on the side of the street. She is looking for a specific person that she knows.
Okay, thank you.
Thank you, Your Honor.
Good afternoon, Chief Justice Gantz. Good afternoon, Your Honors. May it please the Court, Paul Rudolph on behalf of the defendant, Marcus Thomas. I'd like to begin in the reverse order and begin by addressing the identification of my client, Mr. Thomas. The efficacy of cautionary advisements in significantly reducing the risk of a misidentification is utterly uncontroversial. It's clearly established in the scientific literature. It's been recognized.
Doesn't it matter if the person knows the person we're trying to identify? Isn't that relevant?
It's not relevant to the question of whether or not an identification procedure is unnecessarily suggestive. That's really a question of reliability. It maybe goes to the question of whether there's an independent source to permit a later identification procedure, but it is totally irrelevant to the question of whether or not this identification was unnecessarily suggestive. Beyond that, Justice Budd, the evidence in this case showed at most a limited familiarity between this witness and the individual she knew as Marcus. She was asked specifically how often she had seen him in the past, and she said, quote, "Not that often. We don't associate with the same people." When she was asked for specifics about when she had seen him in the past, she gave one example, said, "I seen him at a party." And this is at Record Appendix 37 and 40 to 41. When she was asked for a description of him, all she was able to give was kind of chunky, looks like he's 19 or something. When she was asked to describe his clothing that night, she couldn't describe a single article of his clothing. So this is not an instance of somebody who knew this individual very well. This is, a family member, a close acquaintance. And I think this court, in your recent jury instructions that you adopted on identification, recognized, and you did base this on the scientific research to some extent because it's cited in the jury instructions, that familiarity is really only diagnostic of reliability if the person identified is a family member, a close friend, a longtime acquaintance. And in fact...
But the fact that they knew each other, can that at least go into the issue of whether or not the defendant meets his burden of showing by preponderance of the evidence that the adequate ID is unnecessarily suggestive?
I don't think it's at all relevant to the question of whether the procedure was unnecessarily suggestive. It's a reliability question, and that's what this court rejected in Johnson and in 1995. And the reason you rejected reliability is because this court, and perhaps more than any other court in this country, has historically and consistently recognized how important it is to deter the police from utilizing unnecessarily suggestive procedures.
I'm not talking about Manson versus Braithwaite. I'm not talking about that issue of reliability saving the identification. I'm just saying that I don't know the answer to this question. The fact that you know somebody, can that go into the calculus of whether the adequate ID is unnecessarily suggestive? I'm having a hard time intuitively understanding why it wouldn't.
I don't see the relevance. I think if the court were to find that it was an unnecessarily suggestive identification procedure, at least under this court's current jurisprudence, and which then goes to the next step of, is there an independent source for a subsequent identification, it's relevant. I know that that doctrine was questioned in the recent Johnson case in the amicus brief that CPCS and MacDill filed, but and I think there's some real questions about in light of the science, about the vitality of that doctrine. But I think if it's relevant to anything, it's relevant to the independent source question, not to the suggestive nature of the procedure.
But is it your view that it's a per se, that basically the failure to give the protocol makes it per se unnecessarily suggestive?
It is my view that at this point in time, Chief Justice Gantz, because it is so beyond dispute that these cautionary advisements significantly reduce the risk of misidentification. When there is an unjustified failure to give those advisements, the result should be the suppression of the resulting identification. Now, here we have an additional problem. They compounded the problem by utilizing a simultaneous display of photographs. But, again, it goes back to the importance of this court, as you've articulated from Johnson up through Walker, when you commissioned the study group to find ways to best deter dangerous, flawed identification procedures.
There's a difference between, I guess I'm looking at the fact of, I didn't realize when that case came out, but if it's 2 weeks ago, Carter, we have a series of cases that have said, post-Silva Santiago, and including Silva Santiago, but post-Silva Santiago said, yes, this is clearly the best practice, and not doing it has these risks, but it's not unnecessarily suggestive such that the suppression, it should be suppressed. So what do we, so I guess here's what I'm saying. It's one thing to say that as a kind of rule, a prophylactic rule, to insist that there be adherence to what we think social science says and police say is best practice, to say, yes, going forward. But it's another thing to say, in this case, it's unnecessarily suggestive, and that means all the other cases would be too, right?
Well, first of all, I think that this court hasn't said since the study group report came out, which was about a year before this identification procedure, that the failure to give advisements coupled with a simultaneous display of photographs doesn't merit suppression. But I think the timing is important, Justice Botsford, because this officer in this case, he knew that he was supposed to give these advisements. He said so. He talked about how the court wants us to do this when he gave the advisements later. And he knew that because you said in Silva Santiago, we expect going forward that the police will give these advisements. We're not yet, essentially you said, at this time, we're not ready to say that suppression is the remedy for failing to give it. But
so what's the case for saying that today?
The case for saying that today is that, number one, it is it is beyond dispute that the social science shows that there is a significant impact in reducing the risk of misidentification when you give these advisements. Number two, this court has said repeatedly that it wants the police to give these advisements and to deter the police from flawed identification procedures. And number three, as the Magdal amicus brief shows, the vast majority of police departments themselves acknowledge the efficacy of these advisements because they've adopted them in their protocols. And so we are now at a stage where it is just so beyond dispute that these advisements have a very significant impact on reducing the risk of misidentification. And if this court is serious about preventing those injustices and about deterring the police from whether it's intentional or careless, as may have been the case here, failing to do something that reduces that grave danger.
Would
The
that
court, it's
apply
time
to
for
your
the court to
case?
put that teeth
Since we
into.
hadn't said that before, would any new rule apply to your case? How your client would basically be carrying the water for everybody coming behind him?
Well, again, I think it should apply in this case because, number one, because you had established the expectation. You hadn't said suppression's the remedy, but you had said to the police, you need to do this. And then the study group endorsed that, recognized the science underlying that requirement a year before that. And again, this officer was aware that he should have been doing that. He just didn't do it for this initial array. So I don't think it's unfair to the Commonwealth at all to apply it in this case.
The standard in Walker, as articulated, was that the ID is so unnecessarily suggestive and conducive to irreparable misidentification that its mission would deprive the defendant of its right to due process. So that word "so" suggests an order of magnitude. Is it your view that the "so" is met in every case, or can we say, okay, well, that's a factor in evaluating whether it rises to the level that it would violate due process, but it may not necessarily dictate that it's a violation of due process?
I would say that because the science has demonstrated how significant these advisements are in reducing the risk of misidentification, and again, it's compounded in this case by the problem of the simultaneous display, and I know that is maybe a little bit more controversial, although I think that the comprehensive field study that was done following Silva Santiago, following Walker, really kind of put to bed the controversy about the superiority of sequential displays. I think where you have those two things working in sort of insidious tandem because they're both aimed at the same problem, which is the problem of an eyewitness either assuming that the police have someone in mind, thinking they're supposed to make an identification, and then engaging in this process of relative judgment. When the police fail to do both of those things that address that very significant inherent problem with any identification procedure, then that is so unnecessarily suggestive that the resulting identification should be suppressed. I also think
Per se, you're saying that it's not a factor, it is the factor.
I would say that where you have both of those things, yes. I think that both of those flaws.
But going to Justice Budd's statement, the danger of the simultaneous is not so much where there is, here, Commonwealth argues, he was looking for Marcus. He was not looking to see who was this person behind him. He's looking for Marcus. That's not really the risk that the simultaneous poses. The risk of a simultaneous photo spread is that you think that the person is there and you're going to choose the person who looks most like the person. And so the risk of a false of a mistaken ID is because you're essentially saying he must be here and this person looks most like him, therefore it's him. When you're looking for Marcus, it's a little bit different, isn't it?
I don't think so, because again, the research on familiarity, and again, we're not talking about somebody she knows well. This is somebody that she believes she'd seen around maybe a couple of times in the past.
She knew his name.
She knew a name. That's right. She believed this person was somebody named Marcus, who she had seen on a couple of occasions.
How long were they in the car? Do we know?
I don't recall what the evidence was about how long they were in the car, but one thing that's important to know is what their positions were in the car.
No, I know the front seat, back seat.
Right. So she probably wasn't looking at him while she was in the car.
But I think she saw him get in, you know.
Yeah, so she may have seen him for a matter of seconds, maybe a minute, as he got into the car, and then they're driving. I don't think that means that she was staring at his face. She wasn't able to describe an article of his clothing, so it's not at all clear that she got a good
How
look at
important
this
is
person.
that if she knew who he was? I mean, that's important if you don't know who you're looking for, and the police need to know how to narrow the universe of people who fit a description.
I don't think it's easy necessarily to identify somebody who you may have seen on one or two occasions for brief periods of time in the past.
If you assume familiarity as opposed to disputing familiarity, where does that get you in terms of the science, in terms of these factors, and whether or not it's a per se due process violation?
Well, if we assume limited familiarity, then the science tells us that limited familiarity in some circumstances can actually increase the risk of misidentification. So I don't think that familiarity, the research on familiarity is muddy, to say the least. And so I think it's really dangerous to say, in an instance like this, where there is a very limited degree of familiarity, that means that we should somehow say, all of these two very significant problems with the identification procedure, it's okay. We're going to let the ID come in anyways. Again, I just think that it's really important to go back to the fact that this court, I think probably more than any other in the country, has historically and consistently recognized the critical need to deter the police from utilizing flawed and dangerous identification procedures. And this is an opportunity for this court to hold that when the police, without justification, fail to give these clearly effective advisements and then utilize a simultaneous display of photographs, that the result should be suppression in order to deter the police going forward from utilizing this type of flawed procedure. I see that my time is up. If there are no more questions, I'll rest on my brief.
Thank you.
Thank you.